Yes, hi everyone. In this video, I'm discussing the reply to the defense, and that is a pleading. That is a kind of pleading. Now, the reply to the defense needs to be filed based on what is actually included in the defense. Now, if the defense contains just general denials, a reply to the defense will not be needed to be filed, since not filing a reply to the defense in that case means that the plaintiff does not accept and basically impliedly denies and rejects all the allegations included in the defense. However, if the if the defense raises new facts or raises preliminary points of law or even raises positive defenses, it's understandable that those are facts, those are allegations that are independently proved of the claim of the plaintiff. That means that if they are proved, and provided that they are believed, of course, by the court, and accordingly, let's say that in case the plaintiff proves his claim as well, if this special objections or these positive defenses are proved, then they will override the plaintiff's claim, despite the fact that he has proved his claim. So, in this case, the plaintiff will have to answer to these allegations, and the way of answering to them is by filing a reply. This way, he will be able to admit evidence in the trial, in his testimony during examination in examination chief, where he's going to be able to impeach these special defenses, these new facts that he has not touched in his statement of claim. Otherwise, he will be bringing up relevant facts which are not pleaded, and he most likely will not be allowed by the court to admit such evidence. Now, upon those grounds, in this case, then a reply is necessitated. Now, another case where the reply is needed, is necessary, that is when the defendant, for example, brings a counterclaim. When he makes a counterclaim, it should be stated that the counterclaim operates as a claim, as a freestanding claim, as a separate claim. So he may be claiming a defense, and his defense actually will give rise to a counterclaim. His defense will be negating your claim, and at the same time, his counterclaim is going to be giving him rights of claiming for damages. So if you do not answer, if you do not file a reply, then his counterclaim will be a ground, will prove to be a ground for the entry of judgment for the based on the default of filing a defense. So you will be faced with a judgment. The plaintiff will be faced with a judgment based on that counterclaim. So he has to answer it. When he answers it, he does not have to wait until the heading counterclaim begins in the defense, because the defense is actually the counterclaim. The defense, he will have to put a disclaimer clause, join issue, and state that he does not he denies all the paragraphs and all the allegations stated therein in the defense, to the extent that they run contrary. They contradict his statement of claim, his allegations basically, and except for when he expressly admits allegations, and he will have to start basically answering every single paragraph, because we're talking about a counterclaim. We're talking about he does not have to wait until the counterclaim begins, because simply in the counterclaim the other party is going to incorporate by reference what he has mentioned in the defense. So the defense effectually his counterclaim. He will have to start answering as if he's countering a claim. He will have to start answering every single paragraph, raising his defense, and also replying at the same time. Defend basically through every single angle, such as when the defendant does when he files his defense to the plaintiff's claim. In that case, remember, every single paragraph needs to be answered, whether by a denial or by replying. It depends on what the paragraph contains, as I told you, with those special defenses and special facts, preliminary points. Now, also, I want to stress the importance of the joinder of issue paragraph. It's very important that you in the first paragraph, in the outset of your reply, that you put forth a general denial make a general denial of all the allegations contained in the defense, and that in the defense, to the degree that they disagree with your allegations in the statement of claim, except for when you make express admissions. You should state that the plaintiff denies all the allegations and all the paragraphs basically, and every single one of them, to the extent that they disagree with his statement of claim, except for when he expressly admit these facts, or any of these facts. Before I delve any further into the subject, I would like to stress the importance of being aware of the risks that admission contains. When you make admissions, know what you actually admit to. I will start by saying, when you make admissions, the facts that you admit, let's say, since we're talking about the reply, the facts that you admit in your reply concerning either the counterclaim or the defense, you should know what they're all about, what the substance means. You should be well educated on the facts that you admit, because let's say if there's a counterclaim and you admit these facts, then you can run the risk of having a judgment based on admissions entered upon you, and that's if there's a positive defense there, and if you admit it, or if there are certain facts that if you admit may give rise to positive defense, that's going to be the end of your pleading. And since the positive defense is going to override any claim that you have, so be careful. If there are any preliminary points of law, be careful before you make an admission. Even if there isn't a counterclaim, if there is, for example, a counterclaim. Now, if there is a counterclaim, that's a separate claim. If you admit it, then under then there may be circumstances. Then there may be circumstances where the judge might think fit that he can enter judgment upon those admissions, split the trial, and then continue with your claim, and that will take a necessary heavy toll on the plaintiff, who will be exposed to probably execution of judgment. His property might be taken away from him. He will have to pay costs, and maybe his whole object of delaying and stalling the procedure will just go out of the window. So just be careful what you admit. Everything that you admit, I know, saves you time and saves you the effort of proving it, but maybe this advantage weighs a lot less to what you may actually face, the negative consequences of admissions, that they may impact you and have an effect on your case. The reply, positive defenses to the reply. When the defendant files positive defenses to the reply, they need to be answered on. Now, if they're not answered, then the plaintiff runs the risk of not proving his case, because even if he does prove his own, even if he proves his case, his claim, and he provided that he is believed by court, then the positive defense, if it's proved, is going to take precedence over his claim, and he is not going to be able to impeach this positive defense, or this preliminary points of law, whatever it is, this new facts, this novel facts, if he hasn't pleaded them in his reply in the first place. He will not be, because it's a cardinal rule of pleadings that material facts that you do not plead, you are not able to admit as evidence. And this is because if he does not plead them as evidence, then he will not be able to if he does not plead them as evidence, he will not be able to plead them at court. Now the other party, the other party might just say, now the plaintiff might just claim that since the other party has no way of basically replying back to these allegations, how would not pleading them catch the other party unawares or unprepared, since the whole point of basically pleading is being able to not surprising the opposite party, and the other party is basically not going to be caught unawares. He will know what he has put in his reply. He will just not be given the chance to answer back unless he has filed a counterclaim. In this case, it's treated as a separate claim where he can file a reply to the defense. But if he had just filed the defense, the other party will know, the opposite party will know what is contained in that reply, and he will prepare his evidence accordingly in order to counter it. He's just not given the opportunity and the chance to file a further reply to what he states. And with this being said, this is the end of this video. There's many more things to say about the reply, and I will make additional videos on this topic. Now, thanks for watching this. This is not legal advice. Please subscribe to my channel for more videos like that. See ya.